Good evening, everyone. We welcome I, Saksham Malhotra, and Saksham Dudeja, the mediator. We will be starting with the show, interactive session of the Wiki Talks. As you all know, Wiki Talks is an initiative by the Bar Council along with the young lawyers, an initiative in which the lawyers and with the legal communities we interact, we do podcasts and interactive sessions like these. And today, our panelists, we have four panelists with us, speakers. We'll be throwing a light on the topic bail in NDPS Act. We have with us Mr. Parminder Singh Sekhu, who will be discussing about the rigors of Section 637 of NDPS Act, etc. And Mr. Akshay Jain, he's on his way. He will be talking about the overview of the NDPS. And Mr. Saurabh Bhatia, he will be talking about the relevancy of disclosure statements. Also, we have with us Mr. Imran Ahmed Ali, who will be talking about the procedural lapses in investigation. So, sir, we'll be starting with you only since Mr. Akshay is not here. So, we will be asking you to give the overview also or your topic also, sir.
Please, thank you. Good afternoon, friends. Today we are here to discuss about the rigors of Section 37 of NDPS Act. The present Act, NDPS Act, it was constituted in the year of 1985. See, earlier there was a Opium Act the Opium Act is in play. After 85, that was repealed and NDPS was introduced. Just to curb this drug menace in the entire country, there are very hard provisions, strict provisions under the NDPS Act. Earlier than 2001, there is no classification between the commercial, small or non-commercial quantity, and the sentence was minimum 10 years for any recovery under NDPS Act. Till 2001, the amendment came. When there is classification is small quantity, medium quantity and commercial quantity. Three quantities were given by amendment of 2001. So earlier there was no bail in view of the provisions of 37. In 37 there are very strict provisions, and 37 came into play where the recovery of commercial quantity from the constitutional possession of a person, and where the case is under Section 19 of NDPS Act, Section 24 NDPS Act and Section 27A. What are these sections? 19 is regarding the offence committed by the license holder who is having the license to cultivate the opium. So the person who is accused under Section 19, he has directly first satisfied the provisions of 37, then he is entitled for bail. 24 is regarding the smuggling or regarding the import-export. So 27 is financing the any contraband or dealing with the contraband. So these three sections are all the commercial quantities. I also welcome Akshay Jain.
We welcome you, sir.
I'm sorry for being late.
So I am discussing or telling you that where the provisions of 37 and how to provisions of 37 to be satisfied, because there are two things in a 37, twin conditions which we call. First is it is mandatory to give the notice to the public prosecutor. Then public prosecutor has to decide whether he oppose the bail or not. If he is not opposing, then there is no bar for grant of bail. But if he raise the objection for bail, then the court has to record the satisfaction that the person is not the guilty for offence for which he is being prosecuted, and if he released on bail, then he will not commit this offence in future. So this is a very difficult, how the court record the satisfaction at the time of bail, and how court give this opinion or give this finding, that how we as an advocate for a particular person, how we give this opinion or give an undertaking or give a finding that this person after releasing on bail, he will not commit the same offence. So it is totally impossible to comply these conditions of Section 37. 37 is regarding the smuggling or regarding the import export. So 27 is financing the any contraband or dealing with the contraband. So these three sections are all the commercial quantities. Where the case is under Section 19, he has directly first satisfied the provisions of 37, then he is entitled for bail. 24 is regarding the offence committed by the license holder who is having the license to cultivate the opium. So the person who is accused under Section 19, he has directly first satisfied the provisions of 37, then he is entitled for bail. 27 is financing the recently, earlier there was very strict provisions of, complied with these provisions by the Honorable High Court or Honorable Supreme Court. Now, there are certain judgments which are on Section 37, particularly by the Honorable Supreme Court. Thereafter, our Honorable High Court is also lenient for granting the bail. Because there are two things. It is very easy to implicate anyone because the police system in our society is not honest as per me, as per my standing, or as I am doing these cases from last 23 years. So within a week or 2 weeks, I have gone through 2-3 cases where the prima facie it is made out to me, not honorable judge, also satisfied with these things, that this particular case at the bail time we reached to the conclusion that it is a false implication. So who is the investigator, they are not so honest as per my view. So they are just to meet the targets. Why I am saying targets? Now in 2023, I came across one letter issued by a particular one SSP of one district in Punjab, where they gave the targets to the police officials that every investigating officer posted, NGO they called investigating officers or non-gazetted officers posted in the police stations, and the targets were given by the police to at least register one case per month, and if a person failed to register a case, then he faced the departmental action. So when these type of instructions given by the higher officials or DGP level officers, then the false implication is at large. It is very easy, because if any person for the first 29 days failed to register a case, then he know that now on after tomorrow, on after 30th day, he is going to face the departmental proceeding. So he definitely, to meet that target, he do something wrong. It is now how they are planting the false cases. I am giving one more example to you. Why I am saying these things? Because being the Section 37, very stringent provisions. But on the other hand, I always arguing before the Honorable Court, always this thing, that commercial, though it is a case of commercial quantity, but the background has to be seen also, the circumstances has to be seen also. How they, just to meet the targets, these police officials are involving the persons in these cases. Now how I am saying it is very easy to implicate a person in a commercial quantity case very easily. For example, poppy husk is a 50 kg minimum. After 50 kg it is a commercial starts. Okay? And minimum as per the market it is a 1000 or 2000 if for poppy husk. Then it amounts 1 lakh for a false implication if we require 51 kg. And then for similar to the opium. But how they are implicating the persons in these cases? Now for the example, atizolum. Atizolum is a new salt introduced inducted in the NDPS in 2021. And the commercial quantity is 2.5 gram. Though these are used in the tablets and the stress relieving tablet. I think who is the heart patient? Most we are sitting here, our elders, maximum who are having blood pressure or any heart problem. So you find your houses, this tablet is easily available. What are the police is doing now in these days? I came across not one case, at least 100 of cases. They purchase 30 tablets from a shop, 30 tablets, 3 strips, and the cost of that strip is only 10 rupees. So, person investigating officer on a 30th day, when he is not complete his target, he purchased 30 tablets by himself, 30, 40, 50. It amounting rupees 30, 40, 50, maximum up to 100 rupees, because the market price of one strip is 10 rupees. And these 30 tablets are commercial. So this is the fate, how the people are languishing in jails. And now on the other hand for codeine is also another salt, which is under the NDPS Act. Now the codeine is used to treat the cough. Every doctor recommended, if the person, cough patient is there, then the doctor definitely recommended codeine. And I think everybody is having 1 or 2 bottles in his house, codeine. These are a fancy drill, Benadryl, or this Capsule, Rex cough, etc. Now, 10 bottles of that codeine is in a commercial quantity, and the price of that bottle is 60 rupees. Then it is very easy. So that's why I am saying the provisions are very strict. But on the other hand, the investigating agency in these states are not honest, and they are only to meet the targets implicating. That's why, for example, I am giving to one thing more. When I came across these type of cases, I put one of my person from my office, please find out from one police station how they are doing. In Moga police district, we are searching for 2 police stations. One is Tarankot and another Koti. These 2 police stations we came across in 2023, at least 80 to 90 FIRs for 1 year. So, for example, 8 to 9 FIRs per month. And in every case, the recovery is 30 tablets, 40 tablets, 70 tablets, 80 tablets, 100 tablets. So, as per my own view, that these are all false implications just to meet the targets. So, when to comply these conditions, it is very difficult. How the court record the finding? So now recently Honorable Supreme Court said to the twin conditions of the Section 37 that one, the court may delude that firstly on the basis of the custody period. So if we record the finding that the person is not guilty, then the Honorable Court has to give the finding on merits. So it is very difficult for court, and it is a very dangerous also. If at the time of bail court gave the finding that this particular person is not guilty for the offence, then there is no need for further trial. So these, and till date, nobody challenged these provisions of Section 37. These are against the Constitution of India also, because Article 21 or 19 they are violative of that, because when you put a person in the jail, it is not there is any period prescribed for that. If the case is under 37, case of commercial quantity, you put a particular person behind the bar, there is no limit. We keep that person for 6 months, 1 year, 1.5 years, 2 years, because sometimes it takes 5 years to conclude the trials. Last month I did one case where the person is languishing in jail from more than 5.5 years. But due to the provisions of this 37, he is in jail. So it is very difficult to give. What more I said on this issue, as per me, whatever, if any your query or question, then I answer that after my friends.
Thank you so much, sir. You shared from your personal experience, and I'm sure we might be having questions, but we'll be saving those questions for the interactive
Yes,
session.
thank you.
We have Mr. Akshay Jain sir with us, who will be giving the overview on the act itself. Sir, please.
Yes, a very warm welcome to everyone over here. And my regards to my brother sitting on my left and right side. Now I've been assigned the work of giving the overview of the Act. So I'll start with the basic historical background of this Act. This Act came into being with the accent of the President on the 16th of September 1985. Prior thereto, there were 2 enactments which were governing the majority of the field under narcotic drugs and psychotropic substances. One was Opium Act 1878 and the other one was Dangerous Drugs Act 1930. Under the Dangerous Drugs Act, the maximum punishment was 3 years and for a repeated offense, the maximum punishment was 4 years. So in this backdrop of facts, it was considered because all these law governing to narcotic drugs and psychotropic substances, they in fact has their origination from, so all these provisions of the drugs and this narcotic drugs and psychotropic substances, they have its origination from mostly the UN conventions. And as per UN conventions, we, in terms of Article 253 of the Constitutions, certain treaties to which we were signatories, they were adopted as such by the Government of India. So, in fact, with the development of these laws, these provisions, which were discussed in various conventions in United Nations, so it was thought expedient and appropriate by the Government of India to enact a comprehensive legislation on the stream of this narcotic drugs and psychotropic. So in this backdrop of facts, in September 1985, this NDPS Act came into being, with the repealation of the other two acts which I have just referred to. One was Dangerous Drugs Act and the other one was Opium Act. So this 1985 Act, pursuant to which I'll give the overall view of this 1985 Act, it has been amended. This Act, first of all, after its enactment in 85, it was first amended in 89, in which the major amendment was to the controlled substances. Controlled substances were defined under Section 2 of Section 7D, Subsection 7, Section 2, Subsection 7D, Clause 7D, sorry. So this controlled substances are something which aids into the making of this narcotic drugs and psychotropic substances. It's not part of the definition of this narcotic drugs and psychotropic, but they are the aiding substances which aids into the manufacturing of this narcotic drugs and psychotropic substances. So this was the first amendment. The second amendment came into being in 2001, which gives the uniformity of punishment, whereby this small quantity, commercial quantity and intermediate quantity came into being. So that was the major part of the enactment of this amendment of 2001. So 2014 amendment came into being, where the prime object was to wriggle down the effect of E. Mitchell-Ross judgment, which says that only the pure drug content is to be seen instead of the entire quantity. So that was 2014 amendment. Now thereafter, now this NDPS, I'll take you to the basics of NDPS. This narcotic drugs is one aspect, the psychotropic substance is the other aspect. The narcotic drug is prima facie made out in three natural growing plants. One is coca plant, the other one is cannabis, the third one is opium, and which we call as poppy. Its scientific name is Papaver somniferous. So these are the three natural growing plants which contributes majority to the narcotic drugs. So everything which we talk about, narcotic or opium derivative or cannabis or cocoa, they are all derived from these three natural growing plants. Like for cocoa, I take an example of cocaine. This cannabis, we talk about charas and ganja. The opium, we talk about this medicinal diacetyl morphine, which we call as heroin. The other one is morphine. The byproduct is codeine, which my learned friend has also referred to. Codeine, dextropropoxyphene, these are all opium derivatives. They are derived from opium. So, as a matter of fact, the narcotic drugs are primarily consist of these three natural growing products and its further esters, salts and everything, derivatives. So, these are one aspect. The second aspect is psychotropic. Psychotropic are mostly synthetic and very rarely natural growing products. The psychotropic substances are more or less synthetic. They are being synthesized from various chemicals so as to make them a psychotropic substance. The psychotropic substances are defined in 2 subclause 23 of the narcotic drugs and psychotropic substances. It is the central government who is going to issue notifications in relation to the psychotropic substances and it is only then it will be falling part under the definition of 223. So far as one important aspect is manufactured drug. Normally we, in common parlance, which my friend has also referred to because he has got a vast experience, he has referred to that in common parlance we say that whatever is manufactured is a manufactured drug. No, it is not so. Manufactured drug is being defined under section 2 subclause 11. It says that all the derivatives of opium, cannabis and that coca, they are all being, maximum all of being, they are being termed to be manufactured drug but declared by the notification of this by the central government. So that is what is the the intricacies between these definitions of narcotic drug on one side and the psychotropic substance on the other side. So far as overview of the this act is concerned, Chapter 2 defines, this provides for its officers and authorities. Chapter 3 is one of the most important chapters which everyone should take care of because it provides for the substantive offense. And section 8 is the only substantive provision which deals with every violation under the narcotic drugs and psychotropic substances. Section 8 is the governing provision under the NDPS Act which provides for every contravention of the Act itself. So section 8 we need to focus. Section 9 and 10 is virtually the power of the central government to make rules and regulations pursuant to which this narcotic drugs and psychotropic substances rules 1985 came into being on 14/11/1985. So this is the governing provisions which empowers the central government to frame rules. Chapter 4 is penalties and offences, which provides for section 15, the penalty for poppy hair, section 16, 17, 18 onwards, 21 is for this manufactured drug, 22 is for psychotropic substances. All these penalties are provided in chapter 4. So another most important provision is which my friend was referring to, section 35. Section 35 is something which is opposite to the general law, that everyone is presumed to be innocent unless otherwise proved to be guilty by the prosecution. Here in terms of section 35, the presumption of innocence goes. The presumption of guilt is there, but it is the onus of proving himself innocent lies on the accused itself. So this is what one of the peculiar provision which gives rise to section 37, where is a bar for giving bails and everything. So here this culpability is not of the prosecution to prove. It is the defense which has to prove its innocence. So section 36 talks about special courts, which we all know. These are being tried by the special courts. So far as one of the most important aspect is with the introduction of this forfeiture of illegal acquired property, chapter 5A, which was introduced subsequent to amendment, whereby every property which is acquired from this illicit trafficking of narcotic drugs or psychotropic substances, they are subject to forfeiture. So that is the overview of NDPS, subject to what the rule says, because I'm not going into the rules as of now, because others have also to address this August House. So I'll leave it up to her, and I'll be open to any interactive.
Thank you so much, sir. Thank you so much. That was very interesting and interactive. And sir, we have with us Mr. Saurabh Bhatia, who will be talking on the relevancy of
Disclosure
disclosure statements. Thank you.
Disclosure statements are itself defined in section 25, 26 and 27 of the Indian Evidence Act. So section 25 states that any confession or disclosure statement made to a police officer is not admissible. 27, however, says that certain portion of that disclosure statement is admissible pursuant to my disclosure. There should be some recovery, and that recovery should be relevant to the case at hand. Now, latest judgment, now there was judgments on both sides that whether NDPS officials are police officers or not. because to attract the provisions of section 25 to 27, you need to be a police officer. That was settled in Tufan Singh's case in 2021 by the Apex Court, stating that NDPS officers are also police officials, although they do not give a report under 173 and they give a straight away to the special court. But the powers of search seizure were similar, and hence disclosure statements made to NDPS officers also would amount not admissible in evidence. Now, coming to the topic at hand, since we're discussing bail, it would be important to categorize this section 25 to 27 read with section 67 of the NDPS Act in two categories, and the view taken by our court and the Honorable Apex Court in two different categories, that is regular bail and anticipatory bail vis-a-vis the disclosure statements. Now, interestingly, when the matter came up for hearing before the Honorable Supreme Court, on 13th December 2021, Bharat Chaudhary's judgment was delivered by the Honorable Apex Court, stating that Tufan Singh is good in law and regular bail, these disclosure statements are not admissible. They went up a further to say it because, as my senior friend had earlier pointed out, it is so easy to implicate a person with cheap narcotics. Now, disclosure statements can implicate a person without any substance itself. They do not even need to have any substance in their possession, the police officers, and it is merely a statement given by a accused person against himself. Law was very settled on this, that co-accused statement can only be admissible against him if there is pursuant recovery, and it cannot be made admissible for the co-accused. It can only be limited towards his role. But since there was confusion whether this would attract in NDPS cases, it was settled in Tufan Singh's. Then in Bharat Chaudhary's case, the Honorable Apex Court went a step further and said even the call details of WhatsApp calls, etc., if they are not supported by the call excerpts, then that would also not amount to any evidence against the petitioner, and released him on bail. He was earlier granted bail by the sessions. The High Court had cancelled that bail, and Bharat Chaudhary was then upheld by the Honorable Apex Court. Earlier to that, Varinder Kumar's judgment by our Honorable Court had said that since in certain cases the recovery, most of the cases, if the recovery is earlier and then a disclosure is recorded, then also it would not attract section 27, because the wordings of section 27 Indian Evidence Act says that the recovery has to be pursuant to my disclosure. If I am stopped, recovery is made, and then I give a disclosure, then it is also not admissible. For the co-accused also, for me also, because recovery has been made earlier. And that was even, both these judgments were then formed part of Vikrant's judgment passed by this Honorable Court. Now, anticipatory bail becomes a bit trickier, because Tufan Singh's by State of Haryana versus Samarth Kumar, the Honorable Apex Court says that Tufan Singh is not applicable to anticipatory bails. Now here it is my opinion, and I think everybody being a lawyer shares this opinion, that putting fetters over the powers of the sessions or the High Court to decide the bail on its own merits was illegal by the Honorable Apex Court. And more so, it was illegal on that account that Tufan Singh is a 3 judges bench judgment. If they, and it was a reference judgment, if they had the vision that they did not want it to be used in a regular way or anticipatory, a clarification could have been put up before the same bench. Now the Honorable Judge, who was part of Tufan Singh's quorum, passed Samarth Kumar, knowing fully well the rigors of Tufan Singh, but still putting a fetter upon the powers of High Court and the Sessions Court. There are umpteen judgments on this point that any judicial pronouncement, if it is putting a fetters on the powers of the High Court or the Sessions, cannot be a good judgment, and it has to be treated bad in law. And recently in Sukhminder's case, the Honorable Apex Court in SLP Criminal 6811 of 2024 has somehow watered down to Samarth Kumar. It has, if I can just read 2 lines from that judgment. The Honorable Apex Court says, we are conscious of the decision of this court in the case of State of Haryana versus Samarth Kumar. However, if the only evidence against the petitioner is a statement of the co-accused recorded under section 67 of the NDPS Act, which otherwise is not admissible in evidence, then probably we may have to consider the plea of the petitioner for anticipatory bail. And he was released on interim was made absolute thereon. So somehow the Honorable Apex Court has watered down Samarth Kumar, but it needs again the either an application to the Tufan Singh's bench to clarify why it should not be applicable to anticipatory bails, because it is becoming easier and easier to implicate a person without any substance also, let alone a cheap substance. Without any substance a person is apprehended and he has apprehension that he may be arrested. So this implication needs to be stopped, and Samarth Kumar, in my humble view, is not a bad, it's a bad judgment in law. It might be upheld by certain benches of this Honorable Court, but it has somehow been watered down in Sukhminder's case.
Thank you so much, sir. Now we have Mr. Imran Ahmed Ali. So he'll be talking about the procedural lapses in investigation.
Very good afternoon, ladies and gentlemen. It's an extreme honor to share this dais with Mr. Sekho, Mr. Jain, and Mr. Bhatia. My account, however, will be a little different in terms of it will be a personal account of what I have faced in these matters throughout my limited experience at the High Court. When we talk about procedural lapses, one thing that all of us who have appeared in these matters will be able to understand is that there are two constants. Mr. Sekho appearing in that particular courtroom and the story that comes forward in almost 90% of the FIRs. It may be my limited knowledge, however, the FIRs that I have read always talk about a vehicle in which normally two accused are travelling. They see a Naka in front, they stop the vehicle, try to take a U-turn. In the meanwhile, the extra fit police official runs to the vehicle, nabs one, the other runs, he's got a black plastic bag in the hand, he throws that in the field, they go recover that field. That's how the FIR comes about.
Okay, go to sewer. It's always near the sewer.
Comes in the bushes also.
Some in bushes. Sometimes there is a recovery of, in one of the matters when I appeared, there was a recovery from the top left pocket of the accused of 1800 tablets, which even if he would have been holding them like this, it was not possible. Very large pocket.
Big pockets.
So,
Not with tablets, but money.
no, with money. So, the fake factual matrix that comes forward in matters like these, as well as in the other matters that I've seen, they're MACT matters where it's the same story all over again with respect to the eyewitness account. When we talk about the search in the presence of a magistrate, it is always given up. It is in 90% of the cases. And that is where the problem with the introduction of the new BNSS we have to understand, and the Honorable Home Minister also said that there has to be an audio-video recording of these search and seizures. When we talk about international, and all of us, I'm guessing, are on social media, when we see these search and seizure videos that are uploaded over social media, how are those videos recorded? It is because the officer, right before making that search, puts on that body camera. Now, when there is a specific legal provision with the introduction of Section 105 in BNSS, it is still not being done. The limited extent is not only because of the fact that you have to nab the individual. However, the fake, like Mr. Sekho spoke about it, the number of fake cases being planted. I come from a police background and I know two things. NDPS runs contrary to everything else, because no matter which police station you enter in India, you will see a statistics chart. The statistics is crimes against women going down. Pollution is exploding. The population, pollution is also exploding. The population is also exploding in India. However, the crime rate is going down. These are the only matters that in the states that we are dealing with always have an upward trend. And Mr. Sekho very clearly explained to us how that's happening. When we talk about the sample taking, I'll give you an example. The RUCA is the first communication that has to be sent by the officer. Now, in terms of the availability of that RUCA, in cases it comes. However, in one matter which I dealt with, the RUCA prior in time already had the FIR number, the date. The RUCA was pre-timed to the FIR. However, it already had the mention of the FIR number on it. Now, that shows, and by Sir William Blackstone, he had said that it is better that 10 guilty go scot-free than one innocent, gets convicted. Now, this is the case where the complete opposite is happening. In terms of the lack of conscience, on the part of the police officials, where people merely because of getting one extra medal, getting a recommendation, getting a promotion, there are people whose, the liberty, I think the biggest thing that we have in our lives is the liberty that we can exercise. And that is being taken purely because of small monetary, small personal objectives of getting promotions. When we talk about delay in testing, now the fact that when we subject ourselves, when we go to international travel, sometimes, and probably my name somehow, I am called out for that sample random testing. When airports that are screening lakhs of people every day, at the moment of your reaching on your bags, they can take a sample, dip your finger in a particular liquid, that liquid tests color. We are able to keep people for six months, and there are times where people on default bail, I mean, there are times that you, without testing, keep someone behind bars for 6 months. 6 months is a lot of time. When we talk about, I'll give you an example. My first case of this kind, when I joined my office, there was a man, and what happens is that we get used to a tunnel vision. When we start reading cases, right, when we join the profession, we read everything. It takes us probably 3 hours to read the first case, because we read through everything. However, as experience grows, we know what to read, what not to read. Now, in that particular matter, the learned courts below had made a calculation mistake. That calculation mistake was over 1-0. The matter pending here, he had been behind bars for 4.5 years. When I sat and just used one calculator, that man was not in possession of commercial quantity. The next day, those plethora of judgments that we were taking were of no use, because one statement next day to the Honorable Court said that this does not amount to commercial quantity. That man spent 4.5 years in jail for nothing. When we talk about independent witnesses, it might sound like something, and there are so many times that we go into facts of the case, we don't even talk. It's become one of those, the petitioner as a citizen of India, we don't even talk about those prayers. However, when we talk about independent witnesses not being examined, not being joined, how is it that these roads, these public roads during broad daylight, is the police not even able to bring those independent? Yes, the fear of intimidation from the official authorities, fear of being cited in court, fear of repercussions in society is something else. However, it cannot be that 90% of the times, 99% of the time, there is no independent witness willing to come and join proceedings. When we talk about the gazetted officer, it is a very crucial role which, according to me and subject to correction by my fellow panelists, Section 42, search and seizure, I mean, these are provisions of law that have been incorporated where we're talking about liberties of individuals. And it is only on our collective conscience and sometimes stepping out of our roles to actually understand that there is an extreme use of misuse. And it is only us, I feel, who can actually make a difference. There's sometimes, we read a case and we go with a predetermined mind and we say that, there's not much. But I'm again coming back to that same quote that it is better that 10 guilty go scot-free than one innocent languishes in jail. So I was given 5 minutes and I've been given a table tap. So it was lovely speaking, and thank you everyone for giving the opportunity. However, I'm sure we're open for questions after that.
Thank you everyone. I hope it is recording well. We have a YouTube channel as well on Witty Talks, and we are on Instagram as well. You can follow us and see the videos of ours, which I will also be doing, because I have much to regain. There are much more cases that were discussed. So the interaction session goes on. Anyone with the questions, please, we'll be providing you the mic.
That's very big one. That's a very big one. And for that you need an initiative much larger than what we have.
I'm here for the first time. I just wanted to see who are the organizers, what do you do? I am very much thankful. I gave hats off to you. You are doing such sessions, and everybody from the bar should come here. It must be a larger aspect. And in interactive sessions or like this session, there must be two speakers. Mr. Jain should be against 37. Shekho should be for the 37. That it would have been balanced. If everybody is against 37 or against NDPS, against the police or the procedures, then it would not be fair for the prosecution. Being I am the Additional Advocate General Punjab, I have to say
We are very grateful for your presence, sir. Maybe next
sometimes,
time sir.
I'm not so much good orator.
You can be, right now you can be the lead.
As my friend has stated, that Samarth Kumar has been diluted, it's right. In Sukhminder Kaur, it is somewhere diluted only for the disclosure statements. Where the disclosure, where the person run away from the sport, Samarth Kumar is still applicable. Though it is maybe a bad law, but it is there. I once asked Mr. Shekho also during one case that if Samarth Kumar has been overruled, I think my friend has stated that some more judgments are there against the Samarth Kumar. Is it there? Yes. Please tell them so that they may also get the bail. I am always there to be very fair in the court at least.
Yes. Yeah.
Secondly, once we say the police is doing everything wrong, it is not there. Can't we say the drug menace is there? How it is to be cut? It is the second question. Otherwise, I am really thankful to Mr. Jain and Shekho. They have given a very vast, in very few minutes, everything. And Mr. Ali and this also. So grateful. Thank you very much.
What I am experienced, and I shared with all of you. नहीं, you are always from the state and I am from the defense side. है ना? I am not against the police. I am also the part of society. I am having my children, so I am also scared for the future of my children. So I also want to protect my children. But the credibility of, I am not raising objection on the senior officers. I think all the IPS officers and senior officers in Punjab police or in Haryana police, they are doing what they are having a minimum support or having a limited sources. They are doing very well. And it is also, because being the border state, sir, it is very much an issue that we are facing narco-terrorism in Punjab. Because 560 kilometer our border line is with the Pakistan and they daily throwing the contraband. But I am raising this issue for the police officials also. I always respect them because they are maintaining law and order and also this drug menace. But credibility is daily come under the shadow. And daily there are lot, sir, you are also appearing from that side. And we both seeing this thing that every day we are come across for one or two cases. I pray and I request to these officers that we respect them very much, but we want that their integrity is above that everything. So that the one police official registered a case, then there is no need to dilute this section 37 or how to we will deal with this stringent provisions. If the officer is such a caliber, some of the officers in state of Punjab, when he registered on a case, and I read that case, I feel that this is 100% correct case. Because that persons never did anything wrong. They always, when they apprehended, now I giving one more, only taking 2 minutes. This is, Godara Sahib, this is in the year of 2005. On a weekend, I visited to my parents at Sangrur. One day I was from Jirkpur, I boarded a bus, and near the Bhavanigarh, near the Sangrur Lordship, Godara Sahib, there stopped the bus. And in that bus, at least 11 persons were apprehended by the police with contraband. They all are having 10 to 15, whatever. Everyone is having poppias. All came out from the bus. And on what had happened, if that police officer asked me whether anybody is ready to become an independent witness, I definitely, being the officer of court or being citizen, I am ready to become a witness. But nobody asked anybody. And on the next very day when I read the newspaper, out of that 11 persons, 4 were booked in the cases. That is also which Jansa was saying from the SUA. Only 4, 7 left out. When I came across with this police official ਮੈਂ ਕਿਹਾ ਆਪ ਇਹ ਕੀ ਕਰਿਆ ਤੁਸੀਂ ਨੇ? ਕਹਿੰਦਾ ਵਕੀਲ ਸਾਹਿਬ ਬਸ ਅਸੀਂ ਵੀ ਆਪਦਾ ਕੰਮ ਚਲਾਉਣਾ ਹੁੰਦਾ ਜੀ। ਸੋ ਦਿਸ ਇਜ਼ ਦਾ ਹਾਊ ਆਈ ਐਮ ਸੇਇੰਗ that I am the first person, if they done anything proper way, then I respect their investigation and I stand up with the police. But every day, sir, they are doing
Scientific investigation is the need of the hour.
Yeah.
The scientific investigation and the investigation by the books, which is now the part of BNSS also, that is the need of the hour, and we should always look forward for it, that they may be, educated to that extent that they use these scientific investigations at the spot. Because right now, they are doing nothing so far as scientific investigations are concerned. So it is the need of the hour, probably. Then that is what is the BNSS is making an endeavor. Let's see, now in murder investigations, it has to be, it is made mandatory that the team of FSL should visit the spot. So it is now made.
Only one more thing. Now for BNSS, there is a provision of making a videography. 3 days I came across one case. I said that to that person, he was arrested at the spot, as per their case. Video is also there. They said कि वकील साहब इतना तो रिकवरी हुई नहीं, वो तो खड़ के डंडा लेके उत्थे भी जे हिले उन्हें ठोक दूँ, सारा कुछ ले आके उत्थे प्लान, everything is brought by the police officials and they did the videography. So I am again and again saying the credibility and integrity is doubtful, sir. This is the issue. So we request to the state council. I think it is the duty of the Punjab police to appoint certain our law officers. I am also ready, being a officer of court, to guide them, to advise them. Godara Sahib is also ready, because we are ready to give the pro bono services here. No need for any money for that. They depute us for a 1 week or whatever, one session interaction, how we interacted with each other, so that we guide them to curb this drug menace. But they are not interested, nobody. So
Thank you, sir. Sir, like I want to say something. Like Imran Sahib said that there is a provision that video should be recorded for everyone, but it is in the hands of the police when to start, when to stop. In foreign countries, what I've seen, the video is always on.
that's why I am saying body
Yes, sir.
camera is required.
Body camera is required.
When the police officer came on a duty in the morning, he gave his attendance, then body camera should start. And till he is on duty, now what they are doing, for the 10 hours, Gadara Sahib, they are not using any video camera. When they arrested a person under NDPS, suddenly they came with a camera. So if the video camera, my friend is right, if body camera is there, so our Lordship Justice Anmol Ratan Singh tried to deal with this issue, but now Honorable Supreme Court, I think this matter is under consideration before Supreme Court, and in the entire country, 3-4 districts 3-4 metropolitan cities are taken out as Bangalore, so that they start from that districts to use the body cameras. It is very difficult in Punjab.
Yes.
Now recently, one Honorable Lordship Justice N.S. Shekhawat appointed me as a amicus in a case the video cameras installed in every police station. Now the Lordship has given the judgment and given the certain guidelines to some extent that is good for the general public also, because everyone is feel feared to entering in the police station, or they feel that they falsely implicate us. So now the Lordship has passed the directions that every police station, every police post, every CIA staff, where there is an investigation is going on, there should be a camera, even in the lockups also. No area of that particular police station, Madan Sandhu is counsel for the petitioner in that case. So the Lordship has given the judgment, that is Shiloh versus State of Punjab, that it is the duty of the state that for 1 year, 1.5 years, they kept intact that video. It is, if officer said, ki video camera is not working, then directly SHO and the committee which was appointed by the state administration, they are responsible for that. So now I think we are only due to this honorable court, intervention of this honorable court, certain things are coming out. So let us hope our honorable judges are doing very hard to keep check on these false implications. I always pray that only due to the intervention of this honorable court, there is something is in at proper place.
Absolutely.
So if anybody says, ask anything else, otherwise daily.
I have one question.
Ji, ji.
I think the whole discussion is
Just wait for a minute.
somewhat or somehow focusing. It is on the topic is bail actually. So it is somewhat or somehow focusing on the procedural lapses and the fabrication. But how do we see and balance it with the increasing drug problem in Punjab, drug balance in Punjab specifically? I am naming the state. And how do we see the social impact of this in Punjab, and how do we balance that? That is my question. That how do we balance the freedom, liberty, the principle of freedom and liberty, versus the social problem, the dragon that is there. That is my question.
As per my view, only the strict law is not the solution. It is a social problem, brother. So it is the duty, all of us also, we are also responsible, because it is our duty to explain if we come across. I try to convince my clients if I feel that this person is a habitual and using intoxicant. So I try, being a citizen of this country, I always try to convince him, yaar, koi faida nahi. So it is morally, it is the duty of the state government, but they are not doing anything. They are only, their view is कि जी जितने बंदों को हम अंदर दे देंगे, then इससे drug balance ठीक हो जाएगा. What they are doing? They are not tackling with the drug issue. Rather, they are making the experienced criminals. If the person in a jail for
I would
a
add something to my family and friends' view. We have a reformative approach.
but in here,
Here, instead of reformation, we are making them hardened criminals. What we are experiencing nowadays, recently you might have heard of one drug inspector and one DSP being apprehended who was supplying drugs in jails. So now, virtually what is happening, the law enforcement agencies, the DSP was from STF. If I'm not wrong, Mr. Gudara will be, Vivinder Mahajan, if I'm not wrong. This matter is pending in the High Court also. There's one drug inspector called Shishan Mittal. They were involved in supplying drugs to the persons in jails, languishing in jails. What we are trying to make is, instead of reformation, we are trying to make them hardened criminals. We are trying to make them addicted to drugs. So that is what the problem is. The basic concept is that in case if you want to have maintain the balance between this menace as well as vis-a-vis, so the state should be in reformative mood. Rather than making them languishing behind the jails, they should do something which is more in reformation side. So my view is that reformation would be the best way, because undoubtedly addiction has to be treated with some sympathy, some solace.
they are patients.
Yes, sir.
They are patients.
Yes, sir.
That has to be treated with some dignity.
If the money can be taken out of the drug trade, then the drug trade would be very much less. Because addicts, if they are given free of cost what they are addicted to, like the hospitals that they are providing buprenorphine, they are providing Adnon. The identification of the drug addicts, if they are taking heroin, if they are taking opium, that should be caught by the police, supplied freely by the hospitals.
That is still being done.
No, this has a provision under the
But that is not being done. That is just buprenorphine that is being provided.
No, but the fact is that de-addiction center is the biggest menace of drugs in Punjab.
So de-addiction centers are separate. They are providing drugs in the hospitals, government hospitals. They have court centers there. So in those court centers, they are providing.
You are right, brother. You are right. मैं तेरे को basically ना खैरा साहब, I think na state is not so serious.
Please, sir.
Now Haryana government is doing some policies regarding this NDPS matters, na. But I am the citizen of state of Punjab, so it is very difficult for me to raise any issue against the government. But on the ground level, they are not doing anything.
They are pure
So they are only in papers. that 50,000 ਬੰਦਾ ਫੜ ਲਿਆ, ਇੰਨੀ FIR ਦਰਜ ਕਰਦੀ. This is not the solution. So education is the solution to provide the now what is going on? Suppose one person is falsely implicated in a case. He sent in a jail. Gurdwara Sahib, he remained for 1 year. What my client, I am telling from my experience. He said कि जी वकील साहब ਹੁਣ ਤਾਂ 1 ਸਾਲ ਅੰਦਰ ਲਾ ਲਿਆ, ਜ਼ਿੰਦਗੀ ਦਾ ਖਤਮ ਹੋ ਗਈ, ਹੁਣ ਬਾਹਰ ਆਵਾਂਗੇ, ਇੱਕ ਗੇੜਾ ਲਾਵਾਂਗੇ, 20-25,000 ਬਣ ਜਾਊਗਾ, ਚਲੋ ਆਪਦਾ ਖਰਚਾ ਚੱਲੂਗਾ. Because unemployment is also a problem. So the persons who are unemployed, they are also, yes sir.
वन की प्रॉपर पुलिसिंग,
हाँ जी.
पुलिस के को तनख्वाहें बढ़ानी चाहिए और वो क्वालिफाइड लोग होने चाहिए, शायद उससे माहौल बदले.
बिल्कुल हो सकता है.
दूसरा, सरदार साहब ने कहा कि ड्रग उनको दिया जाना चाहिए. एक पार्लियामेंट में ऐसा क्वेश्चन उठा था कि जो नार्कोटिक ड्रग्स हैं, मीन्स प्लांट डेरिवेटिव्स हैं, वो लीगलाइज कर देने चाहिए ताकि केमिकल सिंथेटिक ना हो. ये 2 बातें. थैंक यू वेरी मच.
बिल्कुल जी. आज
बचाओ कर देते सर टोबैको इंडस्ट्री ते
हाँ या बिल्कुल जी. So पता की है, we are being all the officers of court, being law graduates, it is our duty also, if we try to contribute something in to save this society. So my request to all of you, कि जो whenever any client came to you, first you try to inquire whether he is himself addict or why he is indulging in this. If you find or you satisfied yourself that I try in my cases, it is at least in every case I try to firstly find out this thing, like I investigate to from put the questions to that person. So if I satisfied myself कि ये बंदा he is falsely implicated है ना, then I take the case like that. Otherwise ठीक है, if we are do something little in this, then we grab this. Once I admitted one person at de-addiction center also, that is my client, and I make a promise before particular lordship. वो मैंने कहता कि सिक्को साहब मैंने उत्थे admit कर दो, I will grant the bail. He granted me interim bail. I spent from my pocket, and he remained in de-addiction for 6 months at Barnala, and now he is well because he is father of 3 daughters. So I try to have that.
So subject to the permission, just one last thing. Like Mr. Seko very generously.
We have 10 minutes. We can continue because we'll have a cup of coffee after.
Okay, so sir very generously offered a pro bono kind of an approach. If something can be done by the organizers, where those of us, I want to get up on a positive note from here. Yes. So those of us willing to give that assent in terms of no matter what the High Court decides, if we give our assent, we sign and we say that tomorrow if we are needed for pro bono in terms of talking to police officials, in terms to going to one district, explaining in a police station, we should stand up and do it together. Let's stand up on a positive note and actually agree to actually making a change from now.
No, we are ready.
It's very easy to.
We are ready, but problem is, brother. Now I am telling you, state is not a serious. But let us write down some letter to the addressing to the chief minister. If he is so serious, he daily giving the interviews and giving his views on the drug issue. So we will write letter to the chief minister that we are ready to give our services pro bono to help the police, to teach the police, because we are not here to get the relief in every case. Yes. We are here to protect the society also. So because if it is increasing day by day, then it is difficult for us also. We are Jan Sahab are also doing he is on the commist cases. He is expert, and ask him how the commists are being daily implicated. Even they are having bills, they are having proper license, and then as per me or as my brother's view is also this, because he is arguing maximum cases. When person is having a license, having a particular bill for that medicine, and the medicine is recovered from the shop, then how NDPS is made out? This is the duty of the state, because they are not serious.
My brother is absolutely correct. The fact is that you have to make a distinction between what is a substance falling under the NDPS Act vis-a-vis a substance falling under the Drugs and Cosmetics Act. A drug is a drug within the meaning of Section 3B of Drugs and Cosmetic Act and used for a particular therapeutic purposes. once that is used for a particular therapeutic purposes and part of pharmacopoeias, the various pharmacopoeias around the globe, so it cannot fall under the NDPS Act because 1945 Act is protected in terms of section 85, if I'm not wrong, 85. The provisions of the NDPS Act is not in addition, the provisions of the NDPS Act is not in addition to a derogation of the Drugs and Cosmetic Act. So once that section is there, itself there, a drug which has a definite therapeutic justification, which is part of Indian pharmacopoeia, which is part of various pharmacopoeias around the globe, that is absolutely not falling under the NDPS Act. Like for example, my friend has taken a name of atizolam. Atizolam is an anxiolytic drug which is used to suppress the anxiety factor. Sometimes by virtue of anxiety you have muscular spasm. In order to relax that muscular spasm, it rightly acts on your NSAD. This is central nervous system. So it directly affects upon that. So virtually that is an anti-xylotic which used for antidepressant purposes. Atizolam is a drug within the meaning of Drug and Cosmetic Act, forming part of Schedule H1. They have their certain certain controlling factors which are provided under the Drugs and Cosmetic rules. So once a person is, suppose I have been prescribed with clonazepam. So I have a prescription for that. I can keep clonazepam in my pocket. So once clonazepam I am keeping in my pocket, am I a person to be held responsible for under the NDPS Act? I'm afraid to say I'm not. Tramadol was one of the best painkiller. Ultracet was one of the renowned painkiller which was persistent from decades together and was used for every pain, everywhere dam in the body. Even for toothache, even for your ankle ache, everywhere Ultracet was being prescribed. Now it is nowhere in the market. So that's the real problem. I mean, a drug which falls under Drugs and Cosmetic Act, that should have to be taken out from the preview of the NDPS Act. And definitely for therapeutic purposes.
The problem is when a lot of that drug is being used. That is where the problem comes.
Now,
because eventually we are.
no, I'm telling you, there was there were the common salts which were being misused for intoxication purposes. One was diphenoxylate. The other one was dextropropoxyphene, which was with a brand name called. It was Proximon. So diphenoxylate, Lomotil, Momolate, or yes sir. Right, this diphenoxylate and dextropropoxyphene is now not being prescribed anywhere in India. There is no prescription you will find with the name diphenoxylate or Lomotil or dextropropoxyphene, like Proximon or something like that. Now there are many other potent painkillers like Tramadol. Tramadol is much more safer than Spasmoproximon, dextropropoxyphene. So Tramadol is the much better choice than this dextropropoxyphene. Now we have Matrogel. Matrogel is a better choice than diphenoxylate. Diphenoxylate we use for loose motions. So now there is a better choice for better drug choice for these kind of ailments. So now there is no prescription of diphenoxylate and dextropropoxyphene.
Very easy to locate and they are very easy to investigate in terms of having a batch number and a manufacturer.
Absolutely.
And police is not doing it.
No,
Police
let
can
me
stop at
tell you.
cover it.
So far as psychotropic substances are concerned, under the NDPS, there is now the amendment that every manufacturer, every person down the line, they have to file their quarterly returns to NCB, saying that we have manufactured this lot with this batch number, with this quantity of drug, and is being supplied to fla. So you can very well track from those records that from where the drug has originated and it has been used by whom.
And where it has leaked from.
Yes. So everything can be investigated, but obviously that has to be by the investigation.
मैं बता कि why I am requesting the answer. अगर गुजारा था पुलिस ਗੋਲੀਆਂ ਕੈਪਸੂਲਾਂ ਐਂਡ ਦਿਸ ਕੱਪ ਸਰਫ ਦੇ ਕੇਸਾਂ ਨੂੰ ਇਨਵੈਸਟੀਗੇਟ ਕਰਨਾ ਛੱਡ ਕੇ ਐਕਚੁਅਲੀ ਡਰਗ ਦੇ ਮਗਰ ਤੁਰੇ ਹੈਰੋਇਨ ਵਗੈਰਾ ਕੈਮੀਕਲ ਨਸ਼ਿਆਂ ਦੇ ਵਗੈਰਾ
ਹਾਂਜੀ ਹਾਂਜੀ ਚਿੱਟਾ ਮਿਆਓ ਮਿਆਓ
then it is very easy to stop this drug. ਕਿਉਂਕਿ ਕੈਪਸੂਲ ਗੋਲੀਆਂ these are manufactured drugs are included in the NDPS Act and they are wasting their time on this. These are not a such type of dangerous drugs that if any person is using any tablet or any cup syrup as an intoxication, that is dangerous for his or her life.
Sir, after 60 years, I have experienced that everybody, most of the population in India and even abroad, they are on antidepressants, they are on antipsychotics, so they are taking one form or the other these psychotropic substances or narcotic drugs, and they are living a very good life otherwise. उसका कोई साइड इफेक्ट नहीं है. अब एटीजोलाम है, क्लोरिजापाम है, ठीक है, वंस इन अ डे. रात को जिसको नींद नहीं आ रही, अब हमारे जैसे जो लोग हैं जिसको सवेरे डांट पड़ती है साहब से,
किसी के जेब में अफीम मिल जाएगी.
अब साहब क्यों बुलवा रहे हो सबके साथ?
I would cut it here. Jashan ji has a question for the panelists.
I will just add to the things we have thoroughly discussed the problems. If a user or consumer knows how to procure it, how the state or the police officials don't know how to nab that cartel, it's the underlying issue where the drugs are coming from. The bigger picture is that top shelf people are never caught.
The kingpins.
Kingpins are never caught, and then they supply money to whosoever it is. They have this whole business going around. So if that is not caught, it's always the people who are more innocent are being caught and put behind the bars. Maybe like that's the thing.
So पुलिस को अपने दिल पे हाथ रख के शुरू करना चाहिए. और अगर पुलिस चाहे ना, they control this entire drug mess within a 2 years.
Yes, sir, they can.
Honestly, police is doing. They brought back their credibility. So everything is in the
One more
police.
thing which I feel is that we are lacking so behind that people have been using dark web for all these things which we people might not even know how to use it.
Yes.
So dark web is one of the more underlying issues we are not seeing at it.
And the glaring
They are very
factor-
ahead of the state and the police how they can procure it.
And the glaring factor is that they know that VPN use कर सकते हैं and then we can transfer that very.
I'll just,
The VPN is not banned in India. It is going on.
I'll just give us an example. Right after school, I had a junior by 1 year, and he got into the problem of drugs because I came from a police family. His mother came over and said, "Kiji, my son's got into the thing," and he was a first-time user at that point of time. So my mom asked him. She asked him that, "Acha, how did you get it? Who, where, what cost, everything?" He told us, behind St. Stephen's 45, there is a budel. This is the panwala. You go there, you say some 3T, 4T. There was a code word. He said, उसके पास एक तंबाकू का डिब्बा है, उसके नीचे कुछ सिगरेट है, उसके नीचे वो रखता है. इतने ग्राम मिलता है, इतना कुछ, everything. I won't take the name of the officer because he's a family friend, but we went to him. My mom gave him the whole account. Said, this is the boy, this is the name of the shop, this is the panwadi, everything. I can promise you. Next 2 days, the panwadi was gayab. We just marred a chakkar after picking me up from school. We marred a chakkar, that guy was missing from there. The third day, the same man, same sector, standing at the other corner. Selling the same thing. This is my personal account. This is my friend. This is my friend who till today is a drug addict. Till today. And right after school.
So imagine the situation if the first timer gets stuck. There are situations that the first timers get stuck with the police. They are behind the bars, and their future is actually ruined, as sir said. So taking the nap of the top kingpins, we are if the police is going around beating the bush around the small peddlers, so things won't help. Even the Supreme Court has recently suggested to watch Breaking Bad and Narcos, if everyone knows about it.
We can have this after more thanks, being my senior fellow members of the bar, my brother and sister of the bar which has spent their time, I would take this opportunity to thank all the panelists who has given us time from their hefty court list and share their important insight and valuable insight as to enable us to get more deep into NDPS, which actually we also never had that. Our aspect was never there. I would also take this opportunity to thank Mr. Suvir Sidhu for reposing this confidence of me. It is a sense of gratitude to him. Thank you all. Thank you everyone. Please have a cup of coffee. It is there. And now interact. And I would also take this stage to thank Mr. Budara, who had given us time. He is the Additional Advocate General of Punjab. Very hard working, I say.
Very clear.
Very clear of the thoughts. Thank you everyone. Thank you everyone.